I'm ready whenever you are, Mr. Chair.
Okay, all good. So let's go on the record. Good morning. It is 9:35 a.m. and I would like to call today's hearing to order. Before we do that, there are two of us participating pursuant to the just cause provision in case within the legislation involving such attendance. And so at this time, I would like to allow Verdugo Peralta to provide her statement relative to her rationale.
The reasoning is, according to the Brown Act, I have a family emergency. My husband is in the hospital and ill, and I have to make the decisions, so I have power of attorney.
Okay, I would like to lay a motion on the table to allow Ms. Verdugo Peralta to participate in the just cause provision as encased in California. I forget the California government code number. It'll come to me in a second. 54953 F2A.
Second.
It's been moved by Ali and second by Dr. Abraham. Any further question or discussion of that motion? Hearing on the roll call. I'm sorry. I'm having a delay. All right, Dr. Abraham.
Aye.
Okay, let me fix my camera. All right, Ms. Verdugo Peralta,
Abstain?
Mr. Valakapalan,
Aye.
Mr. Pearman,
Aye.
and Ali votes in the affirmative. Similarly, I'm participating pursuant to the just cause provision of California Government Code Section 54953 F2A. I'm also caring for a loved one who, of course, is dealing with a medical matter. And so I would most certainly petition the members of the hearing board to allow me to participate today. It's not often that I utilize this provision, but of course it's necessary. Is there a motion?
So moved.
It's moved by
Second.
Dr. Abraham, second by Ms. Verdugo Peralta. Any further question or discussion? Dr. Abraham.
Aye.
Ms. Verdugo Peralta.
Aye.
Mr. Balakapalan.
Aye.
Mr. Pearman.
Aye.
And Ali abstains on this matter. Proceeding forward, thank you very kindly for members of the hearing board for supporting both motions.
Yes, thank you.
I'm again very much grateful for your benevolence. All right, and compassion. Okay, we have several hearings. Well, actually, one hearing today, a very unique hearing. This hearing involves. Hold on one second. Let me pull this up. Well, before we move forward with that, Madam Clerk, are there any individuals online desires to providing any evidentiary testimony pursuant to the matters that are listed today and or general public comment?
We have one with their people are raising their hands. We have a couple.
Okay, very well. So just as a preface, this is South Coast Air Quality Management District versus Chiquita Canyon LLC, case number 6177-4. So today, just so we're clear, today we're doing 1, request issuance of subpoena, 2, motion to quash, and 3, there's a motion for site visit. Now, I just want the folk online to know you're more than welcome to provide general public comment on whatever the matter is your heart desires. If you're providing testimony, you will assume the oath, prayerfully accept the oath, and then you will provide your testimony, which then will allow both sides to be able to cross-examine you in addition to members of the hearing board positing questions. So to that end, why don't we go ahead and take the first person with their hand raised? Please state your name for the record and speak very loud and clearly. Unmute yourself.
Good morning. My name is Abigail DeSessa. Can you hear me?
Yes, we can hear you.
Thank you. Hello, and thank you, Honorable Chair and Hearing Board members, for this opportunity to share my concerns about Chiquita Canyon Landfill, a Waste Connections company, obtaining very specific information on AQMD's witnesses at this time. From the very start, the residents have been told that their personal identification and addresses will remain private. AQMD guaranteed it was safe to report to them when we are experiencing invasive odors and gases at our homes, businesses, and schools we believe are coming from Chiquita Canyon landfill. Over these past 4 years, many people have moved away, given up reporting because they feel nothing comes of it, and now will have the fear of some kind of possible retaliation. Releasing such specific personal information will make many people feel that they are at risk of witness tampering and intimidation. Currently, Chiquita Canyon landfill already receives very detailed location information of where the odors have been confirmed on each NOV without a direct address or name of the person. I do not believe scientifically there is any more information needed for the landfill to learn about the wind pattern sending their noxious gases to these homes, businesses, and schools. Over the years, if the landfill had good, honorable intentions of going to the most affected people, they have been well aware of those specific people all along. I have publicly stated I would like to be bought out of my property and given proper relocation funds to move away for the safety and quality of life for me and my family. Not once have I been approached with any form of an offer. Not once have I been aware of any person being approached with such an offer. I am a local public figure and community leader. I have been involved in this crisis since the start and have excellent attendance at all meetings. I believe I would be very easy to reach out to if such an offer is even being considered by the landfill. I do not believe that this is the reason for trying to obtain my personal information. Therefore, any reason at this time to obtain my specific information does not seem relevant or helpful to stopping the ongoing crisis. I wish to continue to have the guarantee that has been given to me since the start by AQMD and remain anonymous. I wish to be able to continue to encourage other community members they will be safe if they report what is happening to them and remind them that these reports are important to AQMD doing their job. I respectfully am requesting this honorable hearing board continue to protect AQMD's witnesses already suffering from this crisis. Thank you very much for your time.
Ma'am, do me one favor. Please spell your name for the record. And just to also be very clear, this is general public comment, correct?
I would be more than happy to testify and take the oath.
Okay, just to be clear, you will be providing testimony to the matters that are before the hearing board today. Now, there are very specific matters. They're dealing with the three that I just simply posited. These are not what would typically occur in this type of hearing. I know that it states modification, et cetera, et cetera. However, we're dealing with three matters specific to today. So are you testifying to those matters, or is this just general public comment?
I believe I'm testifying to those matters. Aren't they looking for our addresses and names?
Okay, so not a problem. Then let me administer you the oath. Hold on one second. Because I specifically stated general public comment and or oath, but allow me to administer the oath just so we're all good. Okay, so raise your cameras off, but we're gonna trust and believe that you're raising your right hand.
My camera
Do
is
you-
available if you do want to turn it on.
Okay, please. Yep, please do, just so we can concur that you're in fact raising your right hand to accept the oath. Okay. Are you there?
Yes, I am, and hopefully you can see my name spelled out in the
Well, we need you to state your name for the record, and your camera is still off.
Oh, my bad.
Okay, so just please state your name for the record and spell it. There we go.
Abigail DeSessa, Abigail.
Okay. Go right ahead.
DESA.
Okay. I'm quite confident the clerk's office captured that accordingly. Do you affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Okay, very well. So, just so we're clear, if you can state what you stated before or some version thereof, and then what we'll do is we'll have either side, as well as members of the hearing board, examine as well as question. So
Mr.
go right
Chair,
ahead.
if I
Yes,
may,
ma'am.
this is Catherine Roberts for the South Coast AQMD. We would stipulate to her agreeing to just incorporate her prior statements as attested to under oath if the witness would like to do that.
I
Okay.
agree.
Mr. Dujinski, any comments on that?
No issues with that.
Objections? Okay, thank you. All right, no problem. Okay, we're going to drop over to Elizabeth Jeffords. Elizabeth Jeffords, are you
So,
providing?
Mr. Chair, if I may, I think you should ask for any questions from any of the parties for Ms. DeSessa before she's released, since she's offering testimony.
Okay, hold on one second. Okay, I'm having a delay. All right, there we go. All right, you're absolutely correct. Okay. From the petitioner side, are any questions of?
Thank you very much for your
DeSessa.
testimony this morning, Ms. DeSessa. I have no further questions. Thank you.
Respondent?
No questions. Thank you.
All right, members of the hearing board. Ms. Verdugo Broughton.
Thank you, Mr. Chair. Mrs. Sessa, have you received any negative correspondence or contacts from any source that you feel that you are in any jeopardy of receiving such correspondence?
Previous to these 4 years, yes. It's an older event from regarding Chiquita Canyon landfill.
Okay, can you be more descriptive, please?
Yes, earlier in 2014-15 timeframe when the town was faced with the Chiquita Canyon landfill expansion and Waste Connections already did take ownership of it. It was hotly contested by the neighborhood that we did not, of course, want the expansion. And I was one of the members of the community that my phone all of a sudden stopped working. My landline. I could not call AQMD. It was somehow blocked. And upon the expansion going through, my phone started working again.
So you attribute that to the fact that you were vocal in your protest? I don't understand how any of the entities would have that ability because that would be your phone company, not one of the agencies who has any authority to do such a thing. So I'm bewildered by that.
I understand, however, there was a handful of us very vocal, very public people who lost the ability to use our landlines to specifically call AQMD during that specific time. It's only phone number that wouldn't go through for a group of us.
So are you assuming, or are you testifying that it was one of these specific agencies that were involved?
I happen to believe that somehow Chiquita Canyon landfill found the ability to do this.
And I'm assuming you reported that to your phone company?
We contacted the phone company trying to find out why, and they had no way to figure out why all of a sudden a single phone number wouldn't work.
And to this point, you've never found out.
No, it went back to working as soon as the landfill's expansion happened.
Hmm.
It is completely unexplainable in any other way, and there is a number of us. Which is why I'm afraid of potential, again, potential, intimidation. And I don't particularly want that. And I don't want that for any member of my community.
Nor do we.
Thank you.
And I'm sorry that you had to experience that as well as your neighbors, but I don't understand how that would have happened either. So hopefully going forward, there's not going to be any problems, and one member of the public will be able to contact AQMD at any point in time. Thank you for your testimony.
Thank
All
you.
right, any additional members of the hearing board? Mr. Balakapalan.
Yes, good morning, Ms. DeSessa. I just had it shows you're a resident of Alberti's community. Can you provide what street you're on without giving the street number?
Oh, yes. I live on Cottage Grove. I'm one of, I think, 4 addresses on this whole street. So it's not a secret where I live.
Okay, all right, thank you.
All right, thank you very kindly. Thank you, Ms. DeSessa. We appreciate your testimony. All right, the next person, Jeffers, are you providing or are you providing testimony? Please unmute yourself.
Hi, good morning. Can you hear me okay?
Yes, we can hear you.
Okay, wonderful. Yes, I am providing testimony today and specifically for the agenda regarding the address.
Very well. All right, so I'm going to administer the oath. Do you mind turning on your camera so we can see you?
Sure.
Okay, very well. And then you're going to raise your right hand.
Give me one second. I have this sheet.
Okay, take your time.
Oh, here
There
we
we go. All right. Do you affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, Ms. Jeffers. All right, the floor is yours to provide your testimony.
Thank you. Thank you, board members and chair. In regards to the Chiquita requesting our personal residential addresses, I'd like to say that I have repeatedly filed complaints with both the AQMD and directly with Chiquita Canyon since the very day I smelled them. I've been assaulted in my sleep inside my own home by their toxic fumes. Any conversations that I've had with Chiquita have not gone well. So after a certain point, I only directed my calls and complaints to the AQMD and trust your system. You know, I've lived in Castaic only 5 years, and the entire 5 years I've been sick. Chiquita, it seems like Chiquita operators believe they are above the law and any regulations. We have suffered enough with this abatement process. 5 years with a stipulated order, and Chiquita has managed to make things far worse for us. With this subpoena, they've succeeded in buying more time, and they're buying time while my life slips away. Making an argument to gather addresses that were voluntarily given 5 years ago on this very farm is a waste of the board's time. With all due respect, whatever Chiquita was willing to do to mitigate this crisis, they've already done it. We need our community back and functioning yesterday. And in the meantime, the only addresses that should be disclosed are the addresses for where my family will be immediately relocated to. Thank you so much.
Thank you. Petitioner, questions, cross-examination of the witness?
Thank you, Ms. Jeffords, for your testimony. The district has no questions this morning.
Respondent, any cross-examination or questions?
No questions. Thank you.
Members of the hearing board? Thank you. Mr. Bala, the floor is
yeah.
yours, sir.
Good morning, Ms. Jeffords. Had a question. When you call in the complaint, do you use do you call in or do you use the online complaint system?
When I call into AQMD,
Yes.
at first we use the phone number, but that just takes way too much time. And I suffer from debilitating headaches, migraines, vertigo, memory loss. I can't even remember my own address to put it in. So I'm thankful for the app. I call or I file on the app and get my complaint number right away.
Okay. Just again, without disclosing your actual street number, which is the community and street name you're on?
Sure. I live in Hazley Hills, and my street name is Cambridge.
Could you repeat that again? What?
Yeah, I live in Hazley Hills, which is in
Okay.
Castaic.
Castaic, okay.
The community is Hazley Hills, and I live on a street named Cambridge Avenue.
Okay, thank you.
All right. Thank you. Thank you, Ms. Jeffords.
Thank you.
Madam Clerk, are there any additional speakers? Okay.
We have one more. Where's our two
Okay,
more?
very well. Susie Evans, please turn on your camera. And if you don't want to turn it on, you don't have to. We'd just like to see you and as well as administer the oath if you're going to provide testimony or general public comment.
Can you hear me?
Yeah, do you prefer to turn your camera on or you prefer to leave it
I don't
off?
think I can turn it on.
Okay, not a problem at all. Are you providing general public comment or testimony, evidentiary testimony?
I think we lost her.
Here I am. Do you have me? Oh,
Yes.
there's video.
Okay, are you interested in providing general public comment or evidentiary testimony?
Testimony.
Okay, I'm going to administer the oath. We are on the honor system here, so you're going to raise your right hand. Do you affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
You.
Okay, very well. Thank you very kindly. The floor is yours to provide your testimony.
Many prepared speeches, but Abigail put the nail on the head and then Elizabeth sealed the deal. I live on Lincoln in Valverde. The dump is right behind me. There is just open field behind me to the dump. This has been going on way too long. They've gotten away with everything. They get extensions and all kinds of things that we suffer while they have a good old time doing nothing. Right now, there is a flare or some kind of a pipe that has flames shooting out of it for the last week or more. Nothing there, but I walk out the back of my house and it's so disgusting, and it does get in my house. I can't breathe. I start coughing and a whole load of other things to go wrong. I do know what Abigail said about the phone thing is true. I also know that there are suspicious cars driving by my house when their extension was being waited on. There were things stuck on my fence post and by my mailbox with blatant lies about what's going on over there. I don't trust them as far as I can fit, because I sure as hell can't throw them at 71 years old. This has got to be stopped. They can't get our addresses. They more than likely know exactly where I live because I've been so vocal. They should not be allowed to get anybody's addresses. That's it.
Thank you, Ms. Evans. You will be cross-examined if in fact they're so inclined by the petitioner as well as the respondent. Petitioner?
Thank you, Ms. Evans, for your testimony this morning. The district has no questions.
Respondent,
No questions. Thank you.
members of the hearing board, Ms. Verdugo Peralta.
Thank you, Mr. Chair. Ma'am, how long have you been living there?
I have been living in Valverde since 2000.
And when you purchased your home, was there any disclosure that the dump was there, that in proximity to your home?
I previously lived in Saugus area of Santa Clarita, so I knew all about the dump.
I understand that, but on your documents, was it disclosed when you purchased your property?
I have no recollection of whether it said so or not, but I do know that there was a decision made years ago that the dump would not be allowed to operate past a certain space that they took up or a certain time period. And they exceeded all that and kept going and got caught. And in the last 5 years, it's done nothing but get worse. And if I could move, I would have.
I understand. Thank you for your testimony, ma'am.
Thank you. Any additional comments from members of the hearing board? Questions?
Just,
Mr. Balakapalau.
morning, Ms. Evans. Just quick question. When you call in complain, do you use the app or do you call the toll-free line?
Often. As
Both.
for like yesterday, I didn't get hit with it until I was leaving to go to the heart doctor. So I made the phone call.
Okay. Thank you. No further question.
All right, Natalie Tate. Natalie Tate. Just turn your camera on. Natalie Tate.
Turn on, it doesn't show me where I can turn on a camera.
No
Join as
problem
a
at all.
panelist, stay as
No
an
problem.
attendee, join as.
Okay. And let's go ahead and elevate
Oh,
Jennifer.
I think I did it. I did it. Yay. Can you
All
see
right.
me and can you
You-
hear me?
Yes, we can see and hear you. Did you want to provide general public comment or evidentiary testimony?
This would be the first time that I'd like to provide testimony.
Okay, very well. So then we'll administer the oath. Do you affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do, yes.
Thank you very kindly. All right. The floor is yours to provide testimony.
So I've been a resident. My name is Natalie, Natalie. Last name Tate, Tate. I've been a resident of Valverde in Castaic since 1989. In answering some of the questions for some of the other people, I was never in our real estate. We were not it was not in the documents about the landfill, but we were assuming that the landfill would be closed in the 90s. So since 1989, actually, personally for myself, in May of 2000, I started reporting odors. My actual inspector, Larry Israel, head inspector, has been an inspector to my home since May of 2000. I have been through many reports. I've used both the phone system and I absolutely love the online system because it takes so much less time. In talking about whether or not our addresses will be made public in a subpoena to anyone, anywhere, at any time, that's offensive to me. I don't believe that that needs to be done. I believe that I've been reporting. I've been on the LA Times. I've been on the Daily News. I've been on the Signal. I've reported and reported and reported. I do not think they are good neighbors, and I don't want any of my personal address. I live on Jackson Street, which is actually 2 streets from the landfill. We smell the odors on and off every 24 hours. And personally, I've been assaulted by these offensive odors, gases, and the behavior of the landfill. I've been through many different people at the landfill. I've reported directly to the landfill. They've tried to be helpful. They've tried to put more dirt over stuff. I've just personally had enough of it, and I don't want open reporting of my address. Thank you very much.
Ms. Tate, if you'd hold the line, we're going to ask if the petitioner, as well as the respondent, if they have any questions or would like to examine or cross-examine you, as it were. All right, petitioner.
Thank you for your testimony, Ms. Tate. I don't have any questions from the district today.
you.
Respondent.
No questions. Thank you.
Thank
Members
you.
of the hearing board. Okay, moving down to Jennifer Elkins. Jennifer Elkins, please elevate. Jennifer Elkins, if you'd like to turn your camera on, you're more than welcome to. If not, it's okay. We're on the honor system.
Hi, can you hear me?
We can hear you loud and clear. Which are you providing general public comment or evidentiary testimony?
Testimony.
Okay, very well. Then allow us to administer the oath. Do you affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. The floor is yours to provide your testimony.
Hi, my name is Jennifer Elkins. I've been living in Belverde since 2016. I would like to say that I am completely against our addresses being made public. It has come to my attention that the landfill has been arguing that there's only a handful of residents who are regularly reporting and being confirmed about the odors at the landfill. And they're trying to use that against us to say that only a handful of residents are affected by this reaction. I completely disagree. The AQMD inspectors come out Monday through Friday only. They are not there on weekends. And as you know, most people work Monday through Friday and therefore are not home to report these odors. It does not mean that they are not affected. There are a few of us who are either retired or work from home or we're stay-at-home moms. And yes, we are the ones regularly reporting and we are the ones being confirmed by AQMD because we are home 24/7. This does not mean that my neighbors who have to work and be there at 6 a.m. They call it on their way to work and they're not there to be confirmed when the inspector finally gets there. Every weekend we are inundated with odors on a regular basis. I can call it every Saturday. We smell it and there's no inspector because they don't send them out on weekends. So it's really unfair to say that it's just a handful of people. And so therefore I don't think that these addresses should be given out. They already know who we are. They've been hanging out in front of our house. I know this, the landfill lawyers, I recognized one of them at the court hearing against the county. And she was hanging out in her car in front of our house for hours, in front of our neighbor's house for hours. Doing what? I don't know. We've had folks who have claimed that they work at the landfill, who have dumped their travel trailers or whatnot, their vehicles, their junk on vacant land, claiming that they bought the land. I'm assuming they're trying to intimidate us. And so no more information needs to go out. This is our privacy. We've been through enough. Thank you.
Ms. Elkins, you will be cross-examined by the petitioner. Petitioner.
Thank you, Ms.
Yeah.
Elkins, for your testimony this morning. The district has no questions. Thanks.
Respondent.
No questions. Thank you.
Members of the hearing board. Ms. Peralta, the floor is yours.
Thank you, Mr. Chair. Have you, Ms. Elkins, have you And or your family members have any reported health effects,
Yes.
such as?
My children have suffered from severe nosebleeds. Um, I'm sure you've seen the pictures circulating because they're not normal nosebleeds. It looks like you've turned on a faucet and there's blood pouring down their face. This happens on a regular basis. My husband and I have both broken out in hives and rashes that cannot be explained. The doctors cannot figure out what we're allergic to or why we're having this kind of skin reaction. Respiratory issues, frequent migraines and headaches. Just the daily fatigue. The list goes on. Honestly, it's endless. It feels like this is our new normal, and I know it's not. This is not. None of this is normal.
Thank you, Ms. Elkins, for your testimony. I'm sorry your family is suffering like that. And honestly, I commend all of you for having the courage, despite the fact that you have either been affected by members of whatever entity like that, and you're still willing to come forward and testify. So thank you.
Thank you.
Mr. Vellacaplan.
Yes. Good morning, Ms. Elkins. It's a similar question. Without disclosing a street number, what street are you on in Valverde?
I live in the President Streets in Valverde. I'm on Lincoln Avenue.
I'm sorry, say that again if I missed it.
I'm on Lincoln Avenue in Valverde.
Oh, Lincoln, thank you. And then the other question, so do you normally call in or use the app?
I typically will use I don't use the app. I use the online form. In the years past, I did call in as well, but like others have said, it takes too long and sometimes you can't get through to anyone.
Okay, thank you. I have no further questions.
Thank you.
Thank you. All right, that concludes public comment and or a call for individuals to provide evidentiary testimony. Let's be very clear. No one has sought recognition. Mr. Clerk, please validate what my eyes see along the attendees and participants.
No more.
Thank you very kindly. All right. Down to the motion to quash subpoena deuces take home. Petitioner.
Thank you, Honorable Chair, members of the board. Today, nearly 3 years after this odor event began, Chiquita comes before you claiming that it needs the home addresses of those who complain against it in order to understand the odor event. With this purpose in mind, only one of two things can be true. Either Chiquita never truly cared to understand the odor event over these past years because it never previously asked for complainant home addresses, or the home addresses are not truly necessary for that purpose. The district would argue that the latter is the case. The home addresses are not needed for any material purpose of these proceedings. They are privileged official information, and Chiquita's subpoena should be quashed. Keep in mind when reading the moving papers and listening to the arguments today that this is not a debate between disclosing complainant records with home addresses and disclosing nothing at all. Instead, it's a debate between disclosing the street names where complaints originate and the home addresses where the complainants reside. At its core, you are asked to decide two main issues. First, whether the home addresses would be of any consequence to these proceedings, that is, whether they're material. Second, whether Chiquita needs the home addresses in the interest of justice, and even if some minimal need could be demonstrated, whether that outweighs the public's dire need for confidentiality, because there can be no subpoena for privileged information. First, I'd like to just talk about the facts. Through zero fault of the district, Chiquita already has 27 months worth of complainant data with home addresses to use in their analysis. Chiquita has never sought home addresses in the more than 2.5 years that this odor event has persisted. Chiquita can't properly articulate what it is that they would change about the mitigation measures, the order, or the conditions if they had this data on an ongoing basis. They already receive virtually every other parameter other than the personal identifying information of the person who complained. They receive the date, the time, the street name, the city, and the zip code. And keep in mind, the affected communities are not particularly large. And that's not to downplay the problem, but to understand the scope of what it is they are claiming to request. The majority of the streets are short. These are not isolated odor events. These are not single complainant events. These are not odors that affect just one or two households in these communities. Odor events frequently result in complaints from dozens and sometimes hundreds of co-located homes that provide ample data points for Chiquita's experts and the district to provide analysis. Despite this, Chiquita repeatedly stresses that it is seeking this information somehow for the benefit of the public. But this is the same entity that, on its own volition, stopped the targeted measures that it professes it could use this data for. For example, the Voluntary Community Relief Program that did provide directed relief for relocation, home hardening, and utility bills. Now, it didn't ask for the district's home address data before it made this decision to end its voluntary relief program. It did so based on, quote, this is from its own website, long-term trends in on-site surface emissions data and off-site air quality data. Chiquita already has and has expressed that it already did have all the information it needs to make these sorts of decisions. And the board should view Chiquita's motives and promises to do differently now with intense skepticism. Chiquita stresses that these addresses would be material. At the last hearing, Chiquita presented on 27 months worth of data that included complainant home addresses. These home addresses and the analysis based upon them were of no consequence whatsoever. Absolutely nothing changed as a result. The parties were stipulated, the order was the same, the findings were the same, the conditions were the same. The board did not even deliberate on the information that Chiquita provided. You also heard from the public today. Take, for example, some of the street addresses you heard about. Lincoln, Jackson Street, these are streets that are directly or just 2 streets behind the landfill. What question is left to answer regarding these odors by having the specific addresses rather than just the street names? And again, just because someone doesn't complain doesn't mean that people are not affected. The persons who regularly complain are not synonymous with only those who are affected, and that greatly diminishes the value and purposes for which Chiquita wants this data. But let's take the only example that Chiquita happens to offer in the declaration from Mr. Sullivan. This idea that during a quick downtime, having home addresses would help them decide where to put orchard fans. The implication being that they can somehow direct odors away from the complaining home address that's most affected. Well, number one, the odors would need to be directed away from more than just that house. They need to be directed away from the whole street, the whole community. It wouldn't be sufficient to just not blow them away from one single address. The complaint data isn't real time. Conditions like wind and weather fluctuate on a daily basis. Moreover, Chiquita can already establish a sufficient correlation between downtime and addresses where odors occur because they have 27 months of this data. If they can't figure it out with more than 2 years worth of data, a few more months of data is not going to change anything. Moreover, there are already other, better, real-time sources of data, including odor surveillance and community air monitoring stations, the same data that Chiquita used to base its decision about its community relief monitoring program. Finally, I'd like to talk about the harms, those harms that favor confidentiality, and the fact that they are core and they are real. Chiquita references cases that are not dispositive in these proceedings. In those cases, the thing which the government is protecting is sometimes ethereal or tangential, and the harms to that thing are hypothetical and speculative. But that is not the case here. This is not simply some equipment violations, which the district could discover on its own, and where complaints may be helpful or alertive, but not necessary to finding out about those violations and seeking an abatement against them. Here, the odor nuisance is predicated on public annoyance and harm. That makes the complaints the gravamen of the offense and inherently necessary for the district to ascertain that a violation has occurred. Moreover, the community has perceived Chiquita's targeted community outreach as, quote, and this is from one of our exhibits, attempting to distort the findings and truth of the government agencies working on this crisis. You heard from many of those members of the community today who subjected themselves to cross-examination, though there were no questions, but still, nonetheless, they couldn't know that ahead of time, put themselves as susceptible to the questioning of this board and the parties, to tell you about their trust in the system as it exists, that their complaints are predicated on the promise of confidentiality and the fears of retribution they will have. Now, I understand that, maybe there was some skepticism about the examples of the phone lines, the trailers, people sitting outside homes. But whether you credit those examples or not, think about the fact of the relationship that those people must have with the landfill and the fears that they harbor to even believe that the landfill may have been responsible for those types of things. So at the end, while we strongly believe that there's no basis whatsoever for finding these home addresses to be material or that their privileged nature can be defeated, if you do find against the district and the community on these points, we would strenuously argue for a protective order. Chiquita should be limited to using their analysis of this data in this hearing to only when it pertains to a finding, condition, or modification of the order. There should be no pointless pontification about insights that will have no consequence to these proceedings. And moreover, the home addresses should be completely protected from disclosure in these proceedings or any other. So while they may be permitted to bring forth some analysis, absolutely the home addresses themselves should not be introduced into the public record here or elsewhere. And unless this board has any other questions, I would ask that the district's motion to quash the subpoena be granted, and in the alternative, if not, that a strenuous protective order be imposed. Thank you.
Counselor, please state your name, and if you did before, please pardon me because I was having some issues with my Zoom and connectivity, but just state your name so the members of the public know who you are.
Yes. My name is Ryan Manzel. I'm a Principal Deputy District Counsel, and I represent the Executive Officer in these proceedings and the petitioner for the motion to quash the subpoena issued by Chiquita.
Thank you very kindly. Thank you very kindly. Mr. Dudzinski.
Thank you, Mr. Chair. I'm going to share my screen quickly.
Just for the record, okay. Mr. Dudzinski, can you hear me?
Yes, Mr. Chair.
Yes, state your full name and title for the record so people listening will know who you are.
Oh, not a problem, Mr. Chair. Jacob Dudzinski on behalf of Respondent, Chiquita Canyon LLC.
Thank you, sir.
You don't see him? How about now? Mr. Chair, members of the hearing board, we're here on two items today. I will start off with the first one, which is Chiquita's request for a subpoena, as well as its motion for a site visit. We'll deal with the motion to quash immediately. And I think what we'll sense with respect to both of these items is a common theme, is that what Chiquita is pursuing with both its subpoena and its site visit motion is more information, more data, better decision-making by this hearing board. And so we'll start off with the motion to quash and the odor complaint data that Chiquita is seeking. I think it was recognized in a prior hearing by members of this hearing board that such data is critical. It will help in further analysis. That's the primary job of this hearing board, is overseeing how well we are doing in abating the public nuisance for which this order has been issued. We believe that complete complaint data, including the addresses, will allow us to better evaluate what progress we are making in actually imposing the hundreds of conditions in over 100 pages, which are currently in the stipulated order for abatement. As Mr. Sullivan provided within his declaration in Chiquita's opposition to the motion to quash, there's a variety of analyses that can be done with respect to this data. A few examples are up on the screen right now. Based upon the district's position, it seems that they believe that these are of marginal utility. These don't really move the needle for telling us what's actually going on around the landfill. And I agree that we've been here for 2.5 years already. On the margins is where we're at. We've been getting certain type of odor complaint data for a long period of time. And that only tells us so much. Every time AQMD comes before this board in these proceedings, it tells us how many complaints have been lodged, generally where those complaints are coming from, and maybe some indication of what those odors may have been. We can do better than that. And as Mr. Sullivan showed within his analysis, we were able to identify roughly 50% of the households that were driving notices of violation was equal to about 20 addresses. I don't know about you all, but when I learned of that, I was surprised. Based upon the number of complaints that we've been receiving, I would have expected that this would have been a much larger number. And that moves us into the question about materiality. As the district has spoken about it, they've defined materiality to be something that I believe their words were of consequence. They've interpreted of consequence to mean that if we get this data, it is necessarily going to change a finding that the hearing board is going to find. That's a relatively minimal view of what this hearing board does. Even when we're stipulated and we're seeking good cause to adopt a stipulated order for abatement, this hearing board is still weighing whether or not the conditions that are going to be imposed fit within a rule of reasonableness. Does the impact, which is the data that Chiquita is asking for, that's what that will elucidate, what the scope of that impact is. Does that meet the next steps that we are going to be hopefully imposing when we have stipulated orders for abatement? The same is true in a contested proceeding. The district pronounces as if, well, the hearing board's only job is to determine whether or not Chiquita is in violation if we were ever contested. But the real question is, how far in violation are we? And what does that justify imposing if we were to be in violation? And the position totally ignores that regularly when we come before this board, we are here for a status update. We are trying to determine essentially two things: Chiquita's compliance with the order and whether or not it's working. Having more specific address data will allow us to better evaluate the progress of the measures that we are implementing through the stipulated order for abatement today. The official information privilege. This is probably the hottest topic with respect to the motion to quash. And it animates the privacy interests that we heard from members of the public that came to testify before the board this morning. Those are fair concerns. Chiquita doesn't dispense with that at all whatsoever, but we do think that there are a couple things that undercut the veracity of those concerns. As the district admits, Chiquita already has 2.5 years worth of address data. These complainants, their addresses have already been revealed. Second, what we heard from many of the public members was that they didn't want this information to become public. Issuing data pursuant to a subpoena does not make it public. As the district pointed out in its papers, this is not a Public Records Act request. This is a request to issue this data to Chiquita for use in these hearings. It's not something that's going to be published elsewhere. Given that, all of these privacy interests, and we agree with the district on this point, can certainly be resolved by issuing a protective order along with any subpoena that's provided. That protective order can prevent Chiquita from using the data. It can prevent Chiquita from actually publishing any of the addresses. And many of the concerns, as were espoused by the public, would be completely resolved with a protective order. And so on balance, if we're talking about the usefulness of this data in these continued proceedings, as the hearing board has already recognized in prior hearings, against a privacy interest that can be resolved by a protective order, there's nothing on the other side of the balance if those privacy concerns are resolved by a protective order. We think that supports issuance of the subpoena. Lastly, I don't believe that the district touched upon this in their affirmative argument, but another argument that they had made was that the odor descriptors that Chiquita had requested would essentially be an undue burden to produce those. We understood based upon their arguments that a lot of times we might get some complaints that lodge a hodgepodge of information together, and that might be difficult to pull out. We agree with the district on that. We don't want to force anyone on a very difficult fact-finding mission to try to parse out different pieces of information. But to the extent that, for example, I believe there are questions about the online complaint form, there are discrete data fields where that information could be provided. And we think that for those, that information should be handed over to Chiquita. Unless there are any further questions from the hearing board, that's Chiquita's response.
All right, thank you very kindly. Let us return back to the full screen.
Mr. Chair, I have some follow-up questions.
Go right ahead, Mr. I was just going to call members of the hearing board. Mr. Balaka Palan, go right ahead, sir.
Oh, okay, I've read most of the documents that was provided, but let me cut to the chase. I've heard the arguments, both arguments and from the public members. There is a protective order that was produced. Is Chiquita agreeable to this protective order?
Yes.
So, and the protective order, correct me if I'm wrong, Chiquita is permitted to use the complainant address just for the sole purpose of refining, do data analysis and so forth. They will not provide it to the hearing board or to the members of the public because there's ways of disguising it. Even when you have the street address, when you show the map, you can zoom it up a different level. It won't show that. So basically, the last point, so the protective order, you're agreeable to this and the district is also willing to issue this protective order, addresses the issue and provides what Chiquita wants. The only caveat I'll say is that description of the order, it's a field that's captured. You know, just like if you do it online, when they enter it in, it's captured in the field, the same way that data is entered into the same field. So providing that is useful for the analysis, not just the location address, but the nature, you know, if they're nauseated or they're throwing up, you know, what the nature of the odor, the description of the odor, what the community is experiencing is critical because we just don't need to know where they are only, but what is it they're experiencing? And I think the analysis saying only 33 homes or 20 addresses complaining, that's not relevant. The fact remains they are affected, those 20 addresses, and they're continuing to be affected. And how are they being addressed and how does it change as, you know, with these control measures? So I take it the other way, not saying, hey, let's downplay them because only 20 people are complaining. I understand clearly, as indicated, there are more people who are experiencing but do not call in, you know, and when you get the addresses, you cannot always plot it because you will get about, I've done this before, so I know about 80% match rate if you're lucky, depending on the street file. So that there is caveat on the addresses you get that it's not representative of the community as a whole, you know. And so getting the description of the odor is very important, as well as for the analysis, the location. So I'm not sure why that is an issue because it's already available in the field, in the database. And when they're extracting it, it's just a data dump, basically. It's not anything more. I'd like to add one more thing, and I think this is what has been provided to Sunshine Canyon on a regular basis. I think it's a quarterly report. There is also the report that goes to Sunshine Canyon has actually the final sort of finding by the inspector. And I think that is also useful because that's a field. Every complaint, as we know, is assigned, a complaint number is assigned to an inspector, and there's a final deposition of the complaint. The inspector will say, you know, valid, or, you know, there's a certain codes they use. And that is provided on a regular basis to Sunshine Canyon. I think that should also be added because just providing the address, which is a lot of concern of the public, you know, as value, but you need to know what the complaint is about, what is the description. You also need to know what is the inspector's conclusion on that, you know, and you can weigh it however you see fit, but then you have the full picture, you know. Giving this protective order without having the description is almost, you know, meaningless because you already have the addresses as is indicated from the court records as it's been provided you for two, and you know the data has been provided due to the court summary and judgment and so forth. Plus, as district's motion and response, they said some of the streets are very limited. You go to Google and look up, you actually have the street numbers already. You can easily get those street numbers. They're like maybe like, I think it's Ms. Evans or Ms. Abigail DeSouza testified, she's one of 4 addresses. So it's very easy to get, either in a GIS, geographic information system, you can have the layer which has the track data and you can pull up that. Or if you look up the 4 addresses, you got the street number and the street address. So that's available if you have to do a little bit of mining, but you can get it. So, but knowing if with Ms. DeSouza, when she calls in, she's experiencing nosebleed or she's vomiting, I think that is important. So I agree with the protective order. I think we have resolved this. Both sides have made the argument, but the district has come up with a protective order, which is agreed. And only caveat is I say, wherever you have the description of the order, provide it. Where you have the disposition by the inspector, provide that. So you provide a complete picture besides the physical address.
And if I might, hearing board member Lagapalan, currently Chiquita does receive the disposition, so that would already be included.
Oh, okay, good.
Within whatever data set is provided on a going forward basis, and completely agreed with respect to the odors. Chiquita wants that information. We think it'd be important, and particularly when it's tied to addresses. If we so happen to have a street where we have 4 folks complaining, but they all are saying that they're smelling something different, that would be important. That's just one example. I think what our position is that understanding the district's concern about, yes, there's a data field for online complaints, and if those can get pulled, great. We'd love to have that information. We also understand that when folks call in, the note taking might not make it that easy, but I would welcome the district to respond on that.
Just for a final comment, you agree, are you proposing any changes to the protective order that has been issued by the district?
No.
No, so you're agreeable to the protective order?
Correct.
Okay, so it's ready for the chair to sign if the board agrees. Okay.
If I may just respond, unless you.
And for the record, I don't know what he's talking about, so you could identify what the thing he's talking about in the record. So.
Yeah,
So. I'm sorry, Mr. Honorable Chair. Was there something you were going to say? I didn't want to cut you off.
You were seeking recognition and I was providing as such.
Thank you. So, Member Pearman, I believe it's Exhibit 1 of our reply is the proposed protective order. I think it's approximately 2 pages long, and it essentially details what it is that we asked for in the body of our motion and our reply. In terms of the protective order, and I do hear what you're saying, but protective orders are not perfect creatures. They're fallible. They do fail. Take, for example, the protective order in the federal litigation. Los Angeles County and Chiquita agreed that any home addresses they received under that protective order were to be kept confidential, yet they were disclosed and let out anyway. The most protective thing to do is to leave the home addresses with the district, not to leave it up to chance that the protective order will hold up. Every time these are disseminated, the ability to keep them confidential weakens. So certainly there are limitations in the protective order. We think the protective order is better than nothing. But just because these can be covered with a protective order doesn't mean that they need them to begin with, or that there isn't some chance they get disclosed to the public anyway. So that's our position on that. And I think, as opposing counsel already said, they do get the disposition data. And I think that just reinforces the point that really the only thing we are talking about here is home addresses and the odor description data. They truly do get everything else. And so when you do have these streets that are directly behind the landfill, co-located addresses, hundreds of complaints, and the fact that, yes, we do come before this board, we do tell you about the total number of complaints, but that's because it's a broad abatement order that's meant to address the odors emanating from the landfill and not necessarily a particular address on a particular street. So we think on that basis, the fact that they do already get the disposition data and everything else means that they have sufficient information to determine, as I think this board said at a previous hearing, where those hotspots are, right? Where the critical odors need to be addressed.
So, Mr. Chair, I thought that we would just ask questions, and then once everyone's asked questions, go to deliberation. So Mohan
Yes.
went straight to deliberation, but that's still my plan, if that's okay with you, just
Go
ask
right
questions.
ahead, Mr. Chairman.
Thank you.
Go right ahead.
So first for the district, there's a statement in Mr. Jaginski's declaration, paragraph 5, that just says that the district provided odor complaint data with full address information to the County of LA in a different lawsuit, and the county disclosed this data to Chiquita. So is that true? And can you explain the circumstance of that exchange of information?
Yeah, so it is detailed thoroughly in the facts of our moving papers. So if you do want a very fulsome recitation, it is there. But the short of it is that in that litigation, what the county was seeking was a preliminary injunction. And the relief from that preliminary injunction was to provide directed and targeted relief to residents who were actually affected by the odors. So we provided to the county under a confidential common interest agreement the complaint data. And as you can see from the declaration of Catherine Roberts, the expectation was that the county was going to enter into a stipulated protective order with the landfill that those addresses would not be further disclosed and would be confidential. So the idea is the county needed the addresses to provide relief to the community, and we had assurances that no privilege would be waived and that they would be kept confidential. We never consented to that address, or when I say we, I mean the district. No one at the district ever consented to the information that we gave to the county to be further disseminated or otherwise publicly disclosed. And we would just point out, and I could submit, because we're not debating about this specific data in this context, so I could submit supplementary cases. But there are cases that say when you communicate privileged information under a privilege, it doesn't waive the initial privilege, right? So we had an official information privilege with the county. We had a common interest agreement that preserves the status of that official information, and we communicated it to the county with that understanding. And the protective order that we expected to be sought was sought. Unfortunately, it failed, and so now they have the data.
All right. Now, I think we've covered this, but I want to be clear in terms of what the subpoena asks for. It says they want data that includes the complaint number, the date and time of the complaint, street name, city or neighborhood, zip code, complaints, description of the odor, and a description of South Coast AQMD's disposition of the complaint. So essentially, except for the building number and maybe the description, you feel they're getting everything already?
Yes.
And what about the complaint's description of the odor?
We think that's burdensome to give the description of the odor. We think the disposition is sort of a heuristic for that. If the disposition of the complaint is that the landfill is the source of the odors, the particular description of the odors are likely not really that important in the grand scheme of things. For example, they talk about equipment downtime. Whether it's a rotten egg smell or some other smell, if there's odors that are correlated with equipment downtime, the needed solution is obvious, right? It's to fix the equipment. So we think at this point, when we're 2.5 years in, the descriptions of the odors are probably not that important as compared to the disposition, the time, the date, the street names, and those other materials. And I would just point out too that, in the kind of discussion about privileges and elsewhere, that there is a difference in the ongoing data as compared to the historical data. Right. I think people sort of understand that as things age and time passes, the risks to the community, the risk of harassment or intimidation, these things, lessen or deteriorate with time. I think it's a very different circumstance where you tell the community, on a quarterly basis, the landfill is going to find out who you are. Right. I think that's a very different sort of situation.
Okay, well, I didn't ask about that.
Sure.
We were talking about the description of the odor. So explain why that's burdensome. I mean, if you have to look at a complaint and you have to pull out the street, the date and time, you can't just say, 2 words or 1 sentence in it. They said it smelled like X. Why is that burdensome?
So whether someone calls in to complain or fills out the online form, they're essentially just presented with a box, whether it's like a verbal box of, please describe your complaint, or if it's in the app or online where it's a box that just says, describe your complaint. People can put any amount of information into that. They're not limited. It's not like a selection box of sour milk, rotten eggs, that sort of thing. So sometimes people just provide a narrative. You know, I'm so-and-so, I live at this address, it's this time in the morning, this is what I'm smelling, I'm going to be leaving for work soon. Can someone come out quicker than that? So we have to go through on these days where we may be receiving, you know, for example, I think we gave an event date in November from late last year. You know, we receive over 100 complaints in a day. We have to visually go through each complaint and make a determination of whether something is some sort of personal identifying information that is outside the scope of the subpoena. So their name, telephone numbers, email addresses, we have to redact that. The difference with what we give them now is that information is discreetly asked separately. So there's, like if I would try to describe it for the date and time, like that is logged and recorded automatically and kept in the database. So it's just a matter of telling the system, give me those parameters back. They're kept discreetly and the system returns them to us discreetly. So it's easy to provide those.
Okay, but the order would be in some sort of narrative that the claim provide that's not automatically easy to redact then.
Correct.
Okay. Now, description of South Coast AQMD's disposition, what does that look like? What are you telling them?
So it's the disposition of the inspector's findings. So whether an NOV issued, if the odor was verified, if the odor couldn't be verified, sometimes it's left blank. That's usually what is contained in that field.
Okay. Thank you, Mr. Jaginski. The district's reply brief, I think at page 3, laid out some material based on Ms. Roberts' declaration. And essentially, it talked about the streets being not that long. There was reference to how many houses were in the street. Some streets span only a few hundred feet, et cetera, et cetera. This is in the reply brief at page 3. Have you looked at that? And do you think that they factually misstate the statements there about the length of the streets, et cetera?
I have no basis to say that those are incorrect recitations of how long any of those given streets are. I do think that the conclusion that's driven by the recitation of those lengths, we wouldn't agree with. I believe there's a statement in there that about half the streets or majority of the streets within a given community are, only a third of a mile long. But given the sense of scale here, I believe we've heard testimony that the closest house to Chiquita is only 500 feet away. That's less than a third of a mile away. And they're going to be experiencing different orders than somebody that's even further down the road. And so, while sure, some of these streets may not be that long, at the same time, it doesn't mean that there isn't a differentiation between what folks might be experiencing along those same streets.
Then at page 11 of the district's motion to quash, and Ms. Roberts alluded to this a bit, there's testimony from Mr. Sullivan's testimony that essentially states that the specific street address isn't needed. So do you think they misquoted Mr. Sullivan, or how do you address that?
Well, I think that the framing of it is kind of important. So with respect to that question, we were talking about Mr. Sullivan's analyses based upon what that data can show him. If we're looking at like Met data, trying to evaluate which way the wind's blowing, and whether or not it's possible that the landfill is upwind or downwind of that particular complainant, essentially trying to assess the likelihood that like, okay, this odor probably did not come from the landfill. I think Mr. Sullivan's probably accurate with that. Like we can get by with the information that we're getting. I think what Mr. Sullivan identified was that analysis gets better with better data that we get. And there are likely further analyses that could be conducted. They weren't, thoroughly described anywhere with any of the documents that are currently before the board. But Mr. Sullivan had this particular data set for, I think, a little bit over a month, maybe longer than that, when he first testified with respect to this, and was pretty expressive. These are preliminary analyses. This is a lot of data. This is kind of a start as to what we might be able to do with this. And so while that might be accurate, like, sure, some of these analyses are good enough. But there are others that we think would also likely be developed if this information was provided.
All right. Now there's a statement, I think in page 12 of the motion to quash, that essentially Chiquita posted flyers on the mailbox of nearby residences. Do you agree or acknowledge that was true?
I believe that's correct.
And you say in your opposition at page 4 that if this information provided, it would be narrowly tailored to avoid any disclosure of personal identifying information. Just explain that more in terms of the comments from the people who spoke today and just general knowledge in this world that once you have someone's home address, their life is an open book. You can find out who the owners are, who the tenants are, where the kids go to school, et cetera, et cetera, et cetera. Isn't this pretty open-ended inquiry that this information would allow?
I think if there wasn't a cabining of Chiquita's particular use of the data for purposes of these proceedings, that might be a concern. Chiquita already has 2.5 years worth of this address data. And so it's there. Chiquita is able to use it for at least past looking analyses. Going forward, I guess if there's unique complainants, that could potentially be a concern, but I think that's addressed with the protective order that requires that this use of the data is limited. It only goes to folks that need to use it for those particular analyses. And on behalf of my client, I don't think they have any interest in, figuring out everything about everyone that lodges a complaint with AQMD.
So you, to some extent, you're asking the public to trust Chiquita in this context.
Well, under penalty of a protective order, correct. Yeah.
How is this hearing board supposed to enforce such a protective order or police it?
I believe that would be the district that would need to enforce it. I'm actually not sure that the hearing board could. I believe they probably need to go to court in order to enforce it. I don't think that there's any process by which the hearing board could. Right.
Our order, basically, but we can't police it, inspect it, enforce it at all. All right, thank you.
And so why don't we do this? Why don't we take a 10-minute recess and then we'll come back and we'll pick up Verdugo Peralta. We're off the
Thank you,
record,
Mr. Chair.
10 minutes.
Thank you for calling Temecula Valley Hospital. If you are experiencing an emergency, please hang up and dial 911.
on the record. Back on the record.
Yes, we are.
Back on the record at 11:02 a.m. and the floor is Ms. Verdugo Peraltas.
Thank you, Mr. Chair. First of all, Mr. Jaginski, I really want to know what you mean by the statement that we could make better decisions. What exactly do you mean by that? Because having been involved in this for so many years, I kind of take offense to that. So please explain what you meant.
Now, of course, Hearing Board Member Verdugo Peralta. And to be clear, I didn't intend to say that the decisions being made so far aren't good. My intention was that with better data, we can possibly be getting better information, better analyses, which will allow us to make better evaluations. I think since the beginning and even in prior order for abatement proceedings with respect to Chiquita, we've always taken a very scientific principles first theory to all the ways that we go about addressing odors that could be potentially coming from the landfill. And so it's essentially the general idea that more data we have, the more evaluations we're going to be able to do, and then be able to weigh that against what we might be requiring of the landfill.
So you're saying then that that data that you need to make that analysis has to have the individual addresses? Is that what you're trying to say here?
Well, essentially, yes. Like at least
Okay,
based
well, my
upon
question to you, sir, is that why does it have to be a specific address when you can just name the street and you know what the range is of how far that odor is going and how it's affecting these people? So that's all you really need. You could use a street name. There's so many addresses, so many homes on there. That's all I think, in my opinion, that's you need if you know it's within the range. And taking into, I really don't like the fact that it's more legal than it is concern for the health of the public. That the statement
Ms. Verdugo,
was,
do we have a question for the gentleman?
yes. Well, I did ask the question, why do you need a specific address versus just having a street name? That's my main question. But it's also a fact we're here because we're concerned for the public. We're here because of all of the odor. So why do you have to have a specific address? What's that going to change if you have a range and you have a street name? And I want to know what the specific complaint is from the person, but I don't think that they need to give their address. If they just give their street name and we know that they're within the range, why is that not adequate?
I think that for many purposes, Hearing Board Member Verdugo Peralta, it likely is adequate. If the only question we're seeking to answer is whether or not there was an odor and someone was impacted by it, a lot of this information becomes irrelevant. I think where the power in having the address data comes from is in being able to evaluate against the massive complaints how many
How
individual
can you say that? I'm sorry to interrupt you, but how can you say it becomes irrelevant?
Well, I'm sorry, Mr. Verdugo Peralta, can we have the gentleman answer the
Yes.
second?
Yeah, sorry about that.
Go right ahead, Mr. Jaginski.
It's just upsetting.
Well, and to be clear, I mean, the address data becomes irrelevant for purposes of making that determination. If we're just talking about, okay, whether or not there was an odor in a given general location. But where I think the power of having the actual address data comes in, at least from Chiquita's point of view, is that it allows for an assessment and kind of a speciation of the complaint data that we're receiving. So how many households are we talking about? How many complainants are repeat complainants? How many folks do we see that are getting impacted on a continual basis? We think that's worthy of evaluation when we're determining what next steps should be with respect to the landfill.
Well, I don't agree, and I'm asking you why. Let's say, for instance, there's a street that has 20 addresses on it, and let's say that there are 5 complaints. Well, we know what that percentage is of that street that they are experiencing their whatever the specific complaint is, whether it's nosebleeds or can't breathe, whatever it is. So, to me, and for the concern of the public, because I totally get why they are concerned and feel um, subjected and possibly objected because of the fact I've been on the side of being a public advocate and being targeted and even my name being on a lawsuit many times. And it is concerning, and you do feel vulnerable. And I think that that's what these people are trying to convey. Don't you agree with that? That they are more vulnerable if there are specific addresses out there versus just a street name? Mr. Jatinski, that is the question.
Well, I think that to back it up, Chiquita has 2.5 years worth of the address data already. And so we start from the premise that they have this. The second is that vulnerable, I mean, is it a reasonable concern of theirs? Yes. I mean, absolutely. I think we would all agree with that. I think that with respect to the subpoena that Chiquita is seeking and the protective order that the district has proposed, that we protect against those concerns, that any of these folks are going to be targeted, anything malicious is going to happen with respect to having their address data. I don't think that that would occur.
That's what you're assuming. That's an assumption. And on behalf of those people, I agree that they are more vulnerable, and I don't understand why a street name isn't enough. And if you have a percentage of how many complaints you're getting on that street name, that should be sufficient. Thank you, Mr. Chair.
Any additional questions from members of the hearing? Mr. Verdugo Peralta.
No.
I'm sorry, Mr. Balaka Palan.
Do you have a
Mr.
question?
Balaka Palan. Go
Oh,
right
okay.
ahead. Go
Okay.
right ahead.
Thank you, Mr. Chair. Mr. Mensa, can you give a reference where the protective order? I think some members said they didn't see it. Which document, what date was it attached to?
Yes, so it should be on the actual reply motion. So not the declaration of Ms. Roberts that accompanied the reply, but attached to the actual reply as exhibit number 1 is the 2-page proposed protective order.
And that was dated
January 23rd.
January 23rd.
Yeah.
Okay, so that's where the document is. It was attached, correct, the protective order.
Yes, and just to be clear, I mean, the protective order isn't dated because it's proposed, but the reply was submitted and filed on the 23rd.
Okay, because some members said they didn't see it.
Yes.
That's okay. Thank you for that. Now, let me drill down to the protective order. What's the reason the protective order was proposed?
It's better than nothing. I mean,
okay. All right.
if it were to happen, we'd rather have one than not have
That is
one.
protective. Okay. Now, let me go through the elements of the protective order then. Before that, have you personally looked at the data structure, the database, what is provided when data is extracted from the complaint system?
I have seen sometimes it's provided as a PDF, sometimes as a raw Excel file, but I have seen the data that is provided. Yes.
In your observation, the field where, if they do it online, there's a field where you type in the description of order. That's the same field that is entered when somebody calls in. Is that correct?
Well, at least as I've seen it, when I've seen like actual complaint notification forms, especially if it's like a voicemail, it's like just a verbatim typography of whatever the person said.
And but it's put in the same field.
Yes.
Okay. All right. So let's look at the protective order. So the protective order will include complaint number, date and time of the complaint, full address of the location of the complainant, including building number, street name, city or neighborhood, and zip code, description of the character, nature, and intensity of odors detected by the complainant. So that'll have the description. if it's, when it's available, you know, either they do it online or whatever, when they call in and it's typed in, that'll have the description of what they are experiencing, what the public's experiencing in that field, correct?
That it may also have other information, but I assume that's where they would put it.
Put that in, right, because it's a data field for that particular purpose.
Correct.
Okay, and then the disposition of the complaint, that is the final disposition by the inspector who is assigned to that complaint.
If one is entered, yes.
Is one is entered, yeah, so they will have that. So that's the nature of the data that will be provided on an ongoing basis if this protective order is implemented.
Correct.
Correct, okay. And there's a restriction how this data, specifically the identifying information, which is specifically the complainant address, is distributed, correct?
Yes, there's limitations on how they can use the complaint records generally, and then there are additional limitations on how they can use the identifying information, which is the home addresses.
So, and item 4 says the identifying information obtained by Chiquita pursuant to this protective order shall not be presented to the hearing board, so which is the street address, specifically, introduced in any other forum, or otherwise disclosed to the public, correct?
It does say that, yes.
Yeah, it does say that. So any analysis that is subsequently done, exhibit or testimony, or based on the complaint data shall be presented in a manner that does not disclose any identifying information. So that you believe that they can still display it, but they can hide basically, or not show the level of the exact complainant number, street number, correct?
Yeah, I mean, I think just as an example, the idea would be similar to what they did at the last hearing. I don't believe any identifying information was disclosed. So, that's the concept in practice.
And if they violate this protective order, the district will be the one that's who's going to enforce this protective order.
Yes, I mean, without cribbing my own defense when we have to do that, Mr. Pierman makes a good point that what the method of that would be, or whether a court of proper jurisdiction would recognize this board's protective order, would probably be contested by the parties, I assume. I don't think it's as clean as we file the protective order and there's some sort of sanction, and at the end of the day, if they contravene the protective order, the cat's out of the bag at that point. I mean, you can't put it back in. So,
and it's not up to the hearing board to enforce a protective order, correct? Directly.
That's correct.
Okay. Now, are you familiar with the what's online as far as when somebody submits a complaint or call in a complaint, what the caveat is? What
I may not know the caveat, but I have looked at the submission page.
The submission. Can you just does it? What does it say actually? If you could,
I couldn't say exhaustively. I mean,
is that something you can pull up?
I think we could probably pull it up and share it on the screen. I mean, there's a number of fields which are confined, right? It's a drop-down box. You select something, or fields which require like dates or things like that. But then there is the description box, which is open-ended. And
actually, I'm not looking for that. I'm looking at the caveat. How the confidential information is protected and what circumstances it can be disclosed.
We do have it up on the screen.
Okay, if you scroll down a little bit.
Might be at the top, about your
might
privacy.
be the top.
It could.
If you hover above about your privacy, will contain the disclosure.
Okay, yeah. So could you mind reading that for the record, please?
Sure. It says, I can see it. I can see it up there. It says, it's under a hover over field about your privacy. It says confidentiality of personal information. Under that heading, it says, quote, AQMD maintains complainant personal information such as name, address, and telephone number as confidential to the extent allowed by state and federal law. Such information may only be released under very limited and unique circumstances if required by the California Public Records Act or if requested under a subpoena or used in court proceedings. And then there's another.
No, that's fine.
Okay.
That's fine. I think the rest is on the video if they upload anything. And that's the same verbiage also on when somebody has to call in, information about complaint on the website.
I've never personally called the hotline, so I'm not sure what.
No, not on the hotline, on the verbiage on the hotline about complaints, when you go into You haven't seen it?
Are we the app or phone call?
No, the
Sorry.
phone call. I mean, in general, what the public can expect. If you go to the AQMD website, you'll see
I
that.
think we would agree that we consider these identical. If you
Okay.
call or do it
Or
online,
so
it's a
online. Yeah,
complaint.
it's the same level of protection unless there's
Oh, yes.
Yeah. Okay.
I didn't know if you meant the same disclaimer is communicated or not. I'm not.
No,
we
I
treat
don't
them
think
the
it's
same. Okay,
as far as
understood.
communication, but there is verbiage on the website.
Yes.
On the same thing, yeah. And then when I talk about public records requests, have you had experience where somebody has submitted a public record request for complaint data?
I may have.
I can speak to that. The district certainly has, and we do have a policy that we do redact complainant information like specific addresses or phone numbers or names or email address, personally identifying information under an applicable privilege of the Public Records Act.
Okay, all right. So if the board were to adopt this protective order, you think this, absent of no other, think this is a good first step or good measure to be imposed on Chiquita?
I mean, again, I do think it's better than nothing, but I would just point out the only other protective order that I'm aware of concerning these events did not work, right? The federal protective order, despite both parties agreeing that the address information was confidential, whether it was error or not, the information was still disclosed. So, better than nothing, but if I would evaluate it as being good or a guarantee, I don't know if I would go that far.
So this protective order will be generated between, initially it'll be for the, from September 2025, September 5th, 2025 till December 31st, 2025, by February 28, 2026. And then thereafter quarterly within 30 days of the respective quarter. That's the premise of this protective order, the data dump, basically.
Yeah, so I would just point out two little distinctions. The first is, I believe in their subpoena request, they asked for quarterly data within 14 days. As it's styled in the protective order, it would be within 30 days. So it's an enlargement in that sense. But you're correct in the second sense that it basically, and again, the subpoena that they attached or that they submitted only asked from data from September 5th forward. So the protective order only pertains to that data because that's the only data that's before this board at this time. So we did propose that everything that's already been generated, we produce by a certain date. And then on an ongoing nature, we would produce it within 30 days of the end of the quarter.
And I haven't done a comparison between the request and the protective order. What else is different?
I believe that that's it. I don't know if Mr. Jaginski,
and maybe
may
I'll
have,
ask him. Yeah.
Yeah, you could ask him as well, but
It does omit the request for GIS data. The district has always maintained we don't collect that data, and Chiquita has agreed that they would forego a subpoena for records we don't actually
And
create
GIS
or
is
have.
geographic information
Yes,
system.
like we don't do like a PIN data on a GIS system when you log a complaint. That's just not our process.
Okay.
No, you're right.
Okay, thank you. If I can just follow up with Mr. Dujinsky on this, between your proposed and the protective order issued by the district, what is the difference besides the GIS data?
No, I agree with that recitation. There's functionally no difference apart from the GIS data and the timeline by which data would be produced at the end of a quarter.
Right. Okay. All right. Okay, I got no further question. Thank you.
Any additional, Mr. Pearman?
So to the district, when you receive the subpoena from Chiquita, was it accompanied at that time by a proposed protective order?
No, it was not.
And just to be clear, you're not recommending a protective order. The way I read your reply, you're opposed to grant subpoena, but only if we were inclined to issue it, would you want us to then issue a protective order as partial protection?
Correct. I think it's fair to say our position isn't they can have the data if we have the protective order. It's if we're ruled against, we would at least ask for a protective order. That's our position.
Mr.
Yes, for Mr. Dujinsky. So I see kind of from let me just see which document this was. This was Chiquita's opposition to motion to quash subpoena. And I'm looking at page 6, for example. So the top 1% of complaints were from 31 addresses. And then this is from the December 2025 data. 99 addresses accounted for 3%, and then 20 for half. So if you had this information, the address information, we find out that it really is even as low as only 5 households, and within there maybe only, let's say, 17 humans total impacted by these odors. What are these changes to the mitigation strategy that we're perceiving or anticipating?
I think that's a fair question. And so I think that when the matters come before the hearing board, and I think this was elucidated pretty clearly within the district's moving papers, that essentially we're presenting the hearing board with a lot of information, a lot of data. And it's Chiquita's position, at least, that when the hearing board goes about determining whether or not to impose either new mitigation or modified mitigation, that it's doing an evaluation. You're essentially weighing, like, does this make sense for purposes of this case? You know, with respect to how many addresses are being impacted, whether it's at 5, 10, 15, 1,000. We think that that is an appropriate consideration for the hearing board when it's conducting that evaluation. You know, whether at the end of the day that changes what the hearing board's decision would be, it might not, but we'd entrust that to the hearing board, but we think it's a worthy factor of consideration when it's conducting that evaluation.
So we heard a concern raised by the member of the public. There's fatigue because of, perceptions of lack of response or interventions, or, individuals not believing that anything's going to change, that there may not be as many people calling in, or maybe they are trusting certain leaders to, be the voice or advocates. Do you have any response to the concern that at some point there may be members of the public that have just given up on giving calls, feeling that nothing will change?
I think the response to that is that could certainly happen. I don't think it's Chiquita's position that that's not possible. It certainly could be. I think the issue is that, while we recognize that odors can exist in areas where folks aren't complaining and may be impacted, we have no way to know that if they're not complaining. And so essentially this data set gives us a step in that direction in order to evaluate, does this come to a level where an individual out in the community is going to make their complaint? But I don't think we could say like, okay, well, these are the only areas that an odor could possibly be. But it's something that's worthy of looking at.
Okay, thank you.
Thank you very kindly. Any closing comments, brief closing comments from either the petitioner or the respondent on this motion before the board deliberates and vote?
Sure, I'll keep it brief, Mr. Chair. So maybe I'll just pick up where the last question was there. I think everyone who has questioned, what would the better decisions be? What would actually change with the mitigation? I think those are fair questions because despite us challenging them to do that in our moving papers, despite the questions from this board asking what those things would be, they still cannot actually tell you what different decision it would be that you would make, how it would actually affect the order, how the mitigation strategy would be different, what measures that would that entail, or anything else that would actually be relevant to addressing this problem. Even today, you heard much ado about this one snippet that supposedly 20 home addresses are responsible for 57% or 50% of the complaints. Mr. Dujinsky suggests that that was surprising to him and should be surprising to everyone on this board, but still doesn't suggest what should be different based on those facts. And I would submit to you, nothing would be different and nothing should be different. Whether it's 20, 100, 50, 75, that's over 6. It's a public nuisance. No additional or different measures have been proposed. And I don't think that, as he has himself admitted, they already have 27 months of this data. If 2 years of that data, where a detailed enough of analysis was done to even give you those facts, right? How many complaints make up, or how many households make up those complaints. Despite doing that detailed level of analysis, they cannot actually tell you what would be different as a result. And that's the core question of materiality. That's the difference between relevance and materiality. Sure, is it relevant to these proceedings? Maybe. But is it material? Is it of consequence? Absolutely not. What I would also say is, sure, it's true. They've already had that information, the addresses, and to some extent may already be out there. I mean, we can't, number one, know if people who will complain in the future will be the same people who complained in the past. The situation in Chiquita could get worse. I certainly hope that it doesn't, but if for whatever reason equipment were to fail or odors were to get worse, there could be new complainants, people who might complain, but otherwise may be chilled from doing that upon hearing an adverse ruling from this board. And I would just point out that I think everyone can kind of assume that if Chiquita was going to do something nefarious or harassing with this information, they wouldn't do it while this motion is pending and before they've secured a favorable ruling from this board. So I don't think we can point to them having had the data and what they've done with it vis-a-vis the public as being very convincing at this stage. And what I would just point out is that I don't think we've unfairly characterized anything that happened at a prior proceeding or in our moving papers. And I would point out the bottom line that the conversation that was had with Mr. Sullivan at the last proceeding essentially came down to, isn't knowing the hot spots enough for purposes of these proceedings? And his answer was yes. And so there really is no need for these home addresses. They wouldn't be material. And while I do think that a protective order is certainly better than nothing, I think, again, the safest thing to do is kind of similar to the game of telephone, right? You tell someone to something and then it changes to the next person, the next person. The same thing happens with this information. You provide it to one person and every person that gets it is another area where the system of protecting the information can fail. We've seen protective orders fail in this case. And again, whether that's Chiquita's fault or somebody else's fault doesn't necessarily matter. It just illustrates the point that protective orders are not bulletproof. They are fallible, they can fail, and the best thing to do is to leave this information with the district. Thank you.
Thank you, Mr. Dudzinski.
Thank you, Mr. Chair. I think I'll address each of those issues in turn, starting off with materiality and Chiquita's failure to identify a miracle mitigation measure based upon having this data for a few months. You know, we don't think that that's the standard that's before the hearing board for consideration today. I agree, we would all like to know, based upon this data, what would we do differently? We can only make that evaluation if we continue to receive the data. That's the point. If we're going to develop mitigation measures that are going to continue to improve upon an already very expansive order, Chiquita's position is essentially that the more data, the better. The more we can evaluate, the more we can consider, the more we can see what differences may make based upon operation of the landfill. And so we think that the district saying like, okay, well, Chiquita should tell you exactly what it's going to do, and it's going to tell you how to fix this problem tomorrow, is neglectful of the fact that we've been here for 2.5 years. We've been doing everything based upon the data that we've been receiving, and we still need to address the issue. And that's Chiquita's core point. We get better data, we can potentially make differences, we can potentially make changes. Exactly what those are, I admit, we don't know exactly what those are going to be, but we need time in order to evaluate the data in order to get there. You know, with respect to the fact that some of this data is now in Chiquita's hands, I mean, that was pursuant to a protective order. That's how Chiquita got it. It wasn't anything nefarious. Chiquita didn't like surreptitiously receive this data. And the fact that a different protective order failed also was not Chiquita's fault. It was the party that AQMD gave that data to. It was the County of Los Angeles, not Chiquita, that put it forward on a public docket. And so there's no history here of Chiquita violating protective orders. And indeed, before it came to this hearing board with data during the last hearing, Chiquita reached out to the district to make sure that they were comfortable with what Chiquita was planning to do with the data, and provide them an opportunity to object over Chiquita's use of the data. And so we don't think that that is a consideration with respect to Chiquita's request for a subpoena in these proceedings. And with that, Chiquita would respectfully request that the hearing board grant the subpoena. We agree with the district's protective order, which we think resolves the privacy concerns that have been espoused. Thank you.
Thank you. Deliberation, members of the hearing board, if we can move through deliberation and posit a motion. Mr. Pearman?
Sure. I think I would be inclined to grant the motion to quash in full. There's really two factors here. There's the need for this information of the specific street addresses, and then the privacy, if you would, risk from doing so. We've got Mr. Sullivan's prior testimony that there really is no great need for this, and he did not submit a contradictory declaration in regard to today's proceedings. Otherwise, I've seen no evidence that the specific addresses would really aid in resolving the issue here. How would that have stopped the elevated temperature? How would that have stopped the leaching or come up with a solution? No one has provided any evidence at all that that would happen. The response to the questioning from Cynthia and the doctor at those same points were compelling. There was nothing that the attorney could really give us that has any validity. We've had this high-priced multidisciplinary reaction committee appear before us time and time again. I asked this kind of rhetorically, my fellow board members, has any one of them ever suggested, boy, if we just had the street address, we could have fixed this. That would be a solution. Never happened. Never happened over like 4 years. And then the AQMD facts, as stated, were not contradicted by Chiquita, that many of these streets are very short, and so they essentially have all they need if you've got that street of what's happening and the emissions that might be going in odors to that area. So I think in terms of the need for this information, there's a total failure to demonstrate that. And then on the other part of the equation, even if you assume there is some limited, perhaps, need, what about the privacy rights of the complainants? We're being asked to trust Chiquita with a protective order. I'd be more comfortable trusting them if they had even proposed a protective order in the first place. But if the district hadn't opposed the motion, they would have just gotten the subpoena with no protective order in place whatsoever. So that kind of is hard for me to swallow in terms of if I'm a resident, well, we should trust Chiquita, particularly in the face of the flies that they've already put out across the whole neighborhood. The fact that a protective order, so to speak, in this one county rally case did fail, it just shows you how weak those things can be. We don't have the ability as a board to police them. And, I think our charge as a hearing board is certainly not to expose complainants. The district needs those. That's how you find out about polluters. That we can't inspect every place in the county, in the 5 counties. You require complaints. We cannot do anything that creates a chilling effect on people complaining. And I assure you, if we were to grant the motion as proposed, or the subpoena as proposed by Chiquita, every polluter that comes before us, the first thing they want to do is say, I want to get the street address of who's complaining. We can't go that route without substantial evidence that it would change the resolution of a situation. And that is totally failed to be proven here. So I would grant the motion with no protective order.
All right, are there any additional comments? And if not, then go right ahead, Mr. Balakapalan. Then Mr. Pearman, why don't you go ahead and call for the motion?
Oh, just for discussion, I would certainly move that we vote to approve the motion to quash without any protective order.
Second.
Okay, good deal. It's been second, Mr. Balakapalan. There's a motion on the floor, Mr. Balakapalan.
Yes, well, I don't disagree with a lot of the points that Mr. Pearman made, but I think in this situation here, where we talk about chilling effect, whether the public will call in this particular situation, in the Chiquita, the cat is out of the bag. Chiquita has had 2.5 years of complaint data already. And as the district has pointed out, it's easy to find who the complainant now because some of the streets are very small, unlike majority of the streets in different counties, they extend for miles. But here, because it's a unique area, there are 5, 10, 15, or 20 houses along the street. So having the uh, so that having the location data, let me back up a little bit. The whole landfill is mapped. The whole landfill is gridded. The whole landfill has, we know exactly, we've seen countless exhibits showing where all the belts are, based on location. We have now basically, it's advanced in the more, and the rule hasn't kept up with it. They are using drone. They're using drone. They're flying over the landfill, and I don't know, over the community, and they can identify exactly where the hotspot is, where the accidents are, down to the grid, down to the exact coordinate. So what is missing basically is all that integrating that data with the location data will help in trying maybe potentially addressing some mitigation measures. We don't know what they are. We don't know until they can do further analysis, see ongoing data, how the mitigation measures are working, who has been impacted, and how it changes over time. So location is key. Having location, you can integrate all the other disparate data that's out there. There's countless data. We have, like I said, they're now doing aerial. We also now have satellites taking image, and we have seen the plumes going over the community. And not knowing with the location data, you can tell maybe who are the folks who are affected by the community, in the community that are affected. And and I will reiterate that if the sort of cat was not on the bag, if they already didn't have the data, then yeah, I think what I had proposed before was we use provided partial address, not the full address, 95XX, so that you can still do hotspots analysis and so forth with that, with the partial address, not necessarily the full address. For certain type of analysis, you don't need the full address, like hotspots or cluster analysis and so forth. You can still geocode and do with the partial address. But and then the other address point I want to make is the chilling effect. I don't believe after the data is disclosed, we still have a number of complaints. We don't know who they're. So I think the public has known that their data has already been disclosed, but there has been no chilling effect evidence that we have heard saying there's been a chilling effect because of the data is out there. People have still, those who experience the odor, those who have experienced discomfort, those who experience adverse reaction are still calling, and hopefully they will still call and provide that information, and then they can do analysis based on the data and how, if it'll mitigate further, because all this mitigation, we have not seen any reduction per se on the complaints. So will this help? We don't know yet until we provide that data. Even if you want to limit it to a certain time frame, so that they can do further analysis on an ongoing basis, I think that would be prudent to do. So, and for that reason, I would support issuing the protective order and not, as proposed by the district, exactly with no changes.
All right, there's a
I'll make
motion.
Yeah.
Go right ahead.
Oh,
Ms. Verdugo-Peralta.
okay.
Thank you, Mr. Chair. I agree with Mr. Pearman's analysis of this, and that if we proffer that motion as he said, to include that protective order, that I would support that 100%. I do think that there has been a chilling effect, and these people have been still brave enough to come forward. And I'm sure that there are others who have chosen not to because of the fact that their address may be published and that they would also be vulnerable. We don't know that for sure, but we don't know that it's not doing that either. And well, many of them have come before us in the past. I look at them as the leaders of that community and having the will and the fortitude and the courage to come forward, even though they know they may be vulnerable. As I said before, those specific addresses are not needed. A range with street names to me is sufficient. Thank you, Mr. Chair.
Thank you. There's a motion on the floor by Mr. Pearman and seconded by Dr. Abraham. There's no further question or discussion on that motion. Hearing none, Dr. Abraham, your vote?
Chair, can I add one other comment before you take a vote?
Please make it brief, sir.
Yeah, no. I think we heard Ms. Robert saying that the district doesn't do any analysis using the data of the GIS. I would have been more if the district does it. I'm not sure why they don't do it. Let's put it that way. At least they should instead of having Chiquita do this, they can provide the analysis to Chiquita. So that way it's still protected. But at the same time, work cooperatively with Chiquita and see what kind of analysis they need, pay for it. And the GIS. The district has staff who are quite capable in analyzing, using GIS and analyzing data. So it's kind of sad commentary to say that, you have this data and you're not doing any analysis, looking at it, which is really what this is all about, doing data analysis, right? Trying to see how this data will help. Okay, that's all.
Thank you. There's a motion on the floor by Mr. Pearman, seconded by Dr. Abraham. It's been properly moved. Again, there's been ample discussion. Hearing no further discussion on the matter, Dr. Abraham, your vote.
Aye.
Ms. Verdugo-Proughton?
Aye.
Mr. Balakapalan?
No.
Mr. Pearman?
Aye.
Ali votes in the affirmative. The matter is hereby approved 4-1. We'll move very quickly to the motion for site visit. On the petitioner, why don't you go right ahead and open with your argument?
So Chiquita was the petitioner on this one, so I think we'll go first. Okay.
Go right ahead. Absolutely. You're the petitioner. Yes.
I will be very brief with respect to the motion for a site visit. I think we had heard during prior hearings at least some interest on behalf of the hearing board members to be able to physically see the landfill. That was the purpose for bringing our motion. We think that it would be eminently beneficial to the hearing board members to actually get to see what is happening on the face of the landfill and in like respect in the community. I think during one of our prior hearings, we spent well over an hour discussing a particular piece of equipment. There are obviously questions about how things operate at the landfill. And so in short, we think that it would assist the hearing board in continuing to evaluate this case. The district in its opposition to that particular motion raised a variety of concerns. I think they can kind of get lumped into two buckets. One is this would be really hard to do. Chiquita doesn't disagree with that, but we think we could overcome those obstacles. Two are legal concerns with respect to how the hearing board goes about receiving evidence. Essentially, the theory being that, well, the hearing board can only receive evidence when it is in a hearing. Hearing has to comply with the Brown Act. Therefore, if we were to do this, we would have to have a full Brown Act hearing on the Chiquita Canyon landfill. I think Chiquita's position is that while that might be the case, if a quorum of the hearing board were to actually go to the landfill, that it could still allow certain of its members that would be the most interested to make such a site visit. And those hearing board members would then be allowed to report out what their experience has been. And so with that, that is basically the thrust of our motion and the basis. We think that it's still possible, but if the hearing board were to deny our motion, we would respectfully request that that's done without prejudice and with some encouragement for the parties to try and work out a protocol for such a site visit that would work.
Thank you, Ms. Roberts.
Thank you, Mr. Chair. I'll be very brief. The district opposes Chiquita's site visit motion for three primary reasons. Firstly, Chiquita is asking the board to unlawfully forego all of the procedural process of a formal hearing to conduct a private site tour. Second, Chiquita is unlawfully asking to deputize board members to essentially become witnesses in creating and then presenting your own evidence, which fundamentally conflicts with the board's role as an adjudicator of this case and the facts in this case. And three, perhaps most concerning, Chiquita seeks to exclude the public from this entire process. This is not the first time that the district has had to oppose a motion from Chiquita because they are trying to stifle the public's ability to participate in these proceedings. If you want to see a perfect example of public concern, you can look at this Zoom and see that we are several hours into this hearing and there are still members of the public who are watching this hearing because they care. They are involved, and what this board decide does matter to them. The board rejected that attempt to stifle public process the last time Chiquita came here. You should do it again. This board holds public hearings. They are subject to all of the formal rules that are laid out in the district's rules, the hearing board's rules, the health and safety code. The board should not forego those and conduct a private site visit. So the district respectfully opposes the motion in its entirety. Thank you.
Thank you very kindly. Members of the hearing board.
So to ask a
Mr.
question, yes, Mr. Robert, do you recall when this came up, this site visit? Was it the member of the public that proposed that the hearing board members go out there? It wasn't really came from the hearing board, is it? It was the members of the public who were testifying, saying that it really should benefit the hearing board members to go out and experience it for themselves what they are suffering under.
So my recollection is that there was a member of the public who requested the board to take a community tour, not a landfill tour. And then kind of following on at the same hearing, Chiquita requested kind of analogous and lumped it together with the public's request to take a landfill tour. And then I think comments that are from Chiquita cites in their motion were kind of responding to those from the public and the landfill, is my recollection of how that occurred.
So is the district opposed to a community tour if certain,
assuming that there was all of the normal public process. So you have to hold a public hearing, you would notice it, there would still be a quorum. We would not oppose that. Logistically, a tour where you're moving about the community, I would request a little bit of time to work out logistics of how you're doing that. But I don't think we are opposed to a public hearing. If the board wants to move the hearing, the hearing board rules are clear. You can do that. But you don't have the authority, and we walk through this in a brief, to just hold a private tour where you completely cut out the public process. And that's what we're fundamentally opposed to here.
So how do you mention when we had a meeting at the community, but
yes,
that was not really in the community per se. It was at a
so conceivably, one of the logistical challenges is that the most affected community, the Val Verde community, is a relatively small and rural community. It doesn't have a lot of really large public spaces. And one of, the South Coast AQMD is always cognizant when we host a public meeting, we want room for the public to actually attend, right? So we tried to accommodate as close as we could get to the community. And that in that instance happened to be, a community college that was a few miles away. We could certainly revisit that if the board were inclined to try and find a way to go into the Val Verde community specifically. I don't know off the top of my head where that could be held.
Now, why did you single out Val Verde? Because there's several other communities.
There are other communities
that are impacted also.
There's potentially, we could try to find a location like within a community that has experienced these odors. Again, this is still a relatively small area. So things like community colleges tend to be good of they have lots of parking, they have lots of public restrooms, an auditorium, that sort of thing. We would need some similar space for the board to be able to conduct a hearing.
Okay, thank you.
All right, any additional comments from the hearing board? Mr. Pearman.
Well, from reading your papers, in addition to a legal issue about how we could do this without having a full Brown Act meeting, aren't there still safety and considerations and health considerations to having some sort of public hearing at the landfill site?
We would be very, very concerned about trying to host a public meeting on the site of the landfill. There are quite a number of safety concerns.
And from your papers, it seems to me you're suggesting, and I think this is right, any sort of video of what, say, Chiquita wants us to see could be done, and with proper foundation, even a limited narration that's unbiased, and the witness who took the pictures can be here. We could see what they'd want us to see. We could hear what they want us to hear. We just wouldn't be able to smell it, but otherwise we'd get the same effect by a nice video tour of the site in operation if that was deemed useful.
Correct, and the public would get to see the same video.
Thank you.
Mr. Duval-Peralta?
Thank you, Mr. Chair. I was going to exactly propose something like that. Personally, for my purposes, it would be extremely difficult for me to go and see the actual site, but I do really support the idea of having a contractor go out there that would be unbiased, and that they would do a video of the facility and address the areas that we are most concerned about and give us that picture. I think that would be adequate, and especially the fact that we could share that with the public. Thank you.
Dr. Abraham?
Yes, Mr. Duginski, how would you respond to the district's concerns about the impartiality? Let's say we're deputized as witnesses ultimately by visiting it. Wouldn't the date, the climate, like the meteorological conditions, all of those factors impact our experience there, whether we were there on a day that smells good or bad, or do you have any response to that?
Well, I think that general summation is likely correct. The experience at the landfill, I guess, is how I would frame it. It probably changes on a day-to-day, if not hour by hour basis. I think the primary utility in a site visit, in addition to being able to smell the smells, is getting to actually see what the operations look like in general. Those operations also do change over time. Things move. Tank farms, for example, might be relocated, or certain operations may be going on at different points in time. But instead of just the very specifics, it would kind of show the scale as to what is all happening at this particular landfill.
Does Chiquita have any concerns about when the odor nuisances are investigated, whether it's the rules, policies, procedures, protocols that dictate how they do that, because they're reporting back, and confirming. And we've heard witnesses from, your side for sure that have also further elaborated on descriptions of the smell as well. What are we missing?
So what is the hearing board missing with respect to
investigation itself? Your experts have explained the odor. What am I missing about the odor that would change by me being there and smelling it myself?
It would be your own experience of it, essentially. That would be the difference.
Okay. But we have heard from your expert witnesses there were some objective ways to quantify or assess or describe odors, right? Which actually was very helpful, to be honest. I would also wonder, give me one moment. 1 second. I would also just raise the concerns that Board Member Pearman brought up. What is the PPE that would be provided during this visit?
So when we conducted the judicial site visit with Judge Frimpong, it was essentially limited to, I believe, high-vis vests and closed-toed shoes. The district has raised separate concerns over the PPE that they believe would be required depending upon where we would be located around the landfill. It seems like it would really depend on location. If we were going to go right into the heart of the reaction area, that PPE would be probably very different than if we're just kind of taking a tour around the edges of the landfill, so to speak. And so it seems like that would probably be something that would need to be ironed out, instead of saying okay, just here's the one thing that you would need for all places.
Yeah, I would, given all of the concerns that, have been previously raised, the closed-toe shoes, the vests, I mean, exactly what you just said, those descriptions or details are lacking based off of what we've heard. If we're not monitoring our own exposures, if we don't have proper respiration or respirators, I mean, there are all sorts of considerations. If I was doing this as a disease investigation or epidemiological investigation, so the vest and the closed-toe shoes as sufficient PPE, given everything that we've been hearing in the context of the concerns to people's health and safety, is also troubling. Thank you.
Thank you. I'd like to entertain a motion. The members of the
I'd
hearing
like to make a motion that
Go right ahead, Mr.
proceed
Chairman.
any further deliberation. Just I'd move that we deny the requested motion for site visit.
Is there a second? It's been moved by Mr. Pyramid, second by Dr. Abraham on the motion. Hearing none. No further discussion on the matter.
Could I make a brief discussion?
Go right ahead, sir.
Just that I would say, but it's not part of the ruling, but just that if it's the sense of the board, that we encourage the parties to examine whether some audio-visual presentation of the site could be arranged for us to see. And if we determine that is useful and that suggests that a physical presence would be useful, we'd have the right later on to see about some further method of having a hearing out there, but just encourage them to take a look at that option perhaps in the meantime.
Thank you, sir. Mr. Balakapalal.
Yeah, having worked at the agency, I'm a big believer in site visits, and I've done many site visits. You learn a lot and experience. I think it's like watching a travel video of a country. The only thing that is missing is you can see the sights and the wonders, but the smell, the spice, or whatever. So the key here is the odor that the communities experience. We have had very good presentations of what's going on in the landfill by both sides, and the inspector's testimony. But what the community member, I think there was one or two, suggested that really we don't get the full gist of it unless you're there, unless you experience it yourself. But I realize there's logistic issues, the issues with the Brown Act and safety and so forth. But so I'm open to, I don't think we need another video presentation. We already have a good idea what's going on in the landfill. We have all those updates and all those reports, and we have seen, exactly what's going on at the landfill side of it, So, but if they want to do something like that, and then with the caveat that maybe we dismiss it without prejudice so that it can be revisited, I'm okay with that.
All
Mr.
right.
Chair, can I just add really quickly, I want to raise that concern that the impartiality is really important here, and to just counter what Mr. Balagopalan said, I think, honestly, to fairness to the respondent, it would actually harm, I think, this case for us to be so personally affected or impacted by what we experienced there. And I think we've so far done the best we can to try to objectively understand the situation that the public and the landfill are facing. And then I think that there was one other important point here. There's integrity to our investigative processes, and we also have heard from the respondents' experts, and I would not want to jeopardize whether or not we actually support the work of our odor complaint investigators, our air quality inspectors who go out there and do this work and report back. We have the important information from both sides to decide this without my own olfactory senses needing to be engaged in this. And so I just want to elevate the concern that we are really concerned about our ability to remain fair and impartial. And I do think that this site visit would impact that.
All right, just one last caveat to the motion. The motion will be entertained without prejudice. Mr. Pyramid stated that. I just want to be able to underscore that point. Dr. Abraham, your vote?
Aye.
Ms. Verdugo-Peralta?
Aye.
Mr. Balakapalan?
I vote aye.
Mr. Pyramid?
Aye.
Ali votes in the affirmative. The motion is hereby approved unanimously. We have no more business, folks, correct? We're off the record and adjourned at 12:01 p.m.
Thank you, Mr. Chair.
Thank you.
Thank you. Have a good
Thank
weekend,
you.
everybody.